Welcome to the Littleton Chambers podcast.
Good morning, everyone. Welcome to this of the the latest of the Littleton webinars. Today, Charlotte Davies and I will be speaking about vexatious litigants' different approaches. Just a couple of points before we descend into the talk. Sadly, I have another commitment, so I will need to leave bang on 10 o'clock. In terms of questions, if there are any questions that anyone has, please can we ask that you put them in the chat function, and rather than try and address questions as we go along, what we'll seek to do is address the questions at the end of the talk. We suspect the talk will take about 50 minutes or so we should have a decent period for any questions that might arise. So next slide, please. So what prompted this talk was a problem which I dare say a few persons on this call may have encountered. You act for an employer, you are successful in employment tribunal litigation. That litigation is dismissed against the claimant, often, dare I say, a claimant in person, and the tribunal judgment raises questions, let's put it neutrally, as regards the bona fides of the claim. Employer is faced with an enormous cost bill and a potentially impecunious claimant. Now, the traditional view, and advice that I've given on numerous occasions, is that it's a question of, well, you can either pursue your costs or effectively let it go, and victory in the litigation ought to be enough. But that isn't always the case. There's also the difficulty that the unsuccessful litigant is perhaps sometimes unwilling equally to let it go and seeks to engage in further litigation or ongoing correspondence. So what other options are there? And what really prompted this talk was a discussion between Charlotte and I in circumstances where, bizarrely, it was the other way round. So I have a claim where a member of Chambers is acting in a different employment tribunal litigation, and the claimant has brought committal proceedings against the employer in the course of the employment tribunal proceedings on the basis that it is said that the employer has made false statements about disclosure, which led me to look into particularly the question of contempt proceedings, and a discussion between Charlotte and I then prompted this talk. So next slide, please. So what we're going to do is we're going to look at three things. I'm going to speak to you about committal proceedings for the reasons perhaps which I've already explained. I'll then hand over to Charlotte, who's going to deal with injunctions to restrain communications and also civil restraint orders. Next slide, please. So, committal applications. Next slide, please. So firstly, if you've got an individual who has been unsuccessful in the employment tribunal in a manner which raises questions about their honesty, what can you do and where can you do it? Well, if you are so minded, it is open to you to commence proceedings for committal, for contempt, because the giving of false evidence and the making of false statements is obviously something that the justice system is unlikely to smile upon. So if that's what you're minded to do, where can you do it? Well, following Peach and Gray and Somers, it is clear that the appropriate venue in order to commence committal proceedings is and only is the King's Bench Division of the High Court. And you see the passage in Peach and Gray which deals, or Peach Gray, which deals with that point. Next slide, please. So you're in the High Court. The next thing which it's important to recognise is there are two possible types of contempt. I shan't read out that slide there because I dare say you can all read it for yourselves. But what that involves is the Court of Appeal recognising the long-standing distinction between the two types of contempt. The first is a criminal contempt, and a criminal contempt is an act which threatens the administration of justice and requires punishment from the public point of view. The other type of contempt is civil contempt. Civil contempt more traditionally arises in the context of breaches of an order and the like. Next slide, please. So recognising that difference, it's important to see that in the context of the situation which we're discussing in this talk, it's far more likely that you will be seeking to evoke criminal contempt, as I'll explain in the next slide. Because in the context of the employment tribunal, breaches of orders and undertakings is unlikely to be something that you are going to wish to evoke or engage in the expense of High Court litigation. But the distinction between civil and criminal contempt is a material difference because it affects the procedure that needs to be adopted in order for the committal proceedings properly to be brought and considered. Next slide, please. So, making the point that I've already made, you are, in the context of the scenario we're discussing, far more likely to be looking at criminal contempt. And so, for the remainder of this talk, whilst I will deal with the procedural differences between civil and criminal contempt, everything is going to be very much focused on criminal contempt and the routes and tests to be considered in that context. Next slide, please. Remember that because you are in the High Court, you are going to be under the CPR. And compared with the, if I could put it this way, laissez-faire procedural approach that the Employment Tribunal tends to adopt, that is not going to cut it in the context of High Court proceedings. And in the context of committal proceedings, the standard of procedural fairness which is required is even higher. And you'll see there the quotation from Navigator number 1 in the Court of Appeal, where it recognises that in the context of civil contempt, not criminal, and recognise criminal contempt arguably more serious, and we'll come to that in a moment. But in the context of civil contempt, because it's quasi-criminal, it is criminal proceedings for the purposes of Article 6 of the European Convention. Charges raised have to be clear. Criminal standard of proof applies. Respondent has a right to silence. And the final point, which I emphasise specifically, there must be a high standard of procedural fairness. So recognise, if you embark on a criminal contempt committal application, you are going to not only have to cross your T's and dot your I's, but underline them as well. Next slide, please. So, how do you make an application? So, if you are seeking to bring a criminal contempt application, it must be made under Part 8, and which is made plain by CPR 81.3. If it's a civil contempt, you can bring the claim by issuing an application notice in the proceedings, so a standard Part 23 application notice. If you are not, if it's merely civil contempt, you are likely not to require the permission of the court to bring the contempt proceedings. But you do need permission if you are asserting an interference with the due administration of justice, unless it's in relation to existing high or county court proceedings. So that's not going to apply in the context that we're discussing. And if your assertion is, well, this claim was brought falsely, you are going to be asserting an interference with the due administration of justice, and it's not in existing high or county court proceedings, so you will need the permission of the High Court to commence those proceedings. Equally, you need permission if there's a suggestion of knowingly making a false statement in an affidavit, affirmation, or other document verified by a statement of truth. Now, as we'll see, lots of the cases are in the context of a false statement of truth in a witness statement and the like, under CPR 3214. Those principles, however, I consider carry across in the employment tribunal sphere. If somebody gave, for example, false evidence on oath, it would be an interference with the due administration of justice, but the guidance from those cases is also likely to be relevant, I'd suggest. So if you are seeking permission, you need to do so within the application. And the permission decision is taken by a single judge of the KBD or the divisional court. Next slide, please. Now, CPR 81.4 lists a number of things that a committal application must contain. And if it doesn't, it's defective and liable to be struck out. So if this sort of application is to be made, you need the white book or the online version of the CPR available in front of you, and you need to ensure that each and every requirement under 81.4 is being met. A number of them are listed in the precedent court form, so you can tick off a number of them simply by virtue that if you use the correct form, all of these things will be included. But the things that are particularly important to focus on are, number one, the nature of the contempt. So you will need to explain if it's a civil contempt or if it's a criminal contempt, and if so, why it's a criminal contempt. If you are relying on a breach of an order, unlikely in the context we're discussing, but presumably it could apply, you will need to deal with the date and terms of any order breached, including when it was served on the individual and if it bore a penal notice. In the context of the criminal contempt that you're likely to be asserting in the factual situation we're discussing, the key thing is going to be a brief summary of the facts alleged to constitute the contempt, set out numerically in chronological order. So you will need to list each and every occasion when it is said that the claimant, I say the claimant, will be the defendant of the proceedings, claimant in the ET proceedings, has engaged in contempt. So it will need to be, number one, 4th of January 2025 said this. Number two, 23rd of March 2025, during the course of evidence, made the following statements. So it will need to be extremely closely particularized. And as we'll see, if it's not, that's going to cause problems for your application. You are also required to inform the defendant of their right to legal representation, their right to an interpreter, and their right to silence if they choose to evoke it, because these are criminal proceedings, and so there is such a right. They also need to be informed that punishment for contempt can include a fine, imprisonment, confiscation of assets, and that any reduction in, any admission may reduce the sentence. Next slide, please. So, the consequences or the need for procedural compliance. A contempt application must comply strictly with the formal requirements imposed by 81.42. And if it doesn't, then there are going to be significant consequences for the success of the application. And you remember earlier I was saying it's important that each and every allegation is specifically identified, because it is to the matters which are raised in the application notice that the court will confine its consideration. You can look at the supporting affidavit in support in order to determine what precisely the allegations are. But if there's an attempt to prove a contempt which is neither included in the application notice or in the supporting affidavit, then the court will not consider it in the absence of an application to amend. So that's why it's absolutely key that the allegations are correctly identified and set out in the application notice. And because of the high standard of procedural fairness which is going to be required, it needs to be recognised if you don't get it right, you're going to face consequences and potential cost consequences as regards applications to amend and the like. Next slide, please. Now, service. Obviously, in the employment tribunals, service is not something which generally causes great concern. But in the context of a committal application, service is key. So if it is to be served on an individual, and the individual doesn't have a solicitor on record, the application must be served upon them personally. So what you are probably going to want is a process server to hand over the application. So you've got evidence in the form of a certificate of service to demonstrate that the defendant did in fact receive the committal application. If there is a legal representative on record in the proceedings, then you are entitled to serve it on those legal representatives, and that is good service unless they object within 7 days of receipt of the application. If the legal representative doesn't object, it's their obligation to provide a copy of the application and the evidence supporting it to the individual, and to take reasonable steps to ensure that the defendant understands them. If they do object, so situation is legal representative on record, service attempted on the legal representative objects. If that happens, the question of service is referred to a judge of the court, and the judge will consider written representations and make such order as they deem appropriate. Next slide, please. Now, other procedural points. Number one, court has the power to issue appropriate directions, and that includes a bench warrant to secure the attendance of the defendant if appropriate. Court can't compel the defendant to give evidence, as I indicated earlier, criminal proceedings, so right to silence. The court must generally sit in public and inform the press if it doesn't intend to, if it intends to do otherwise. You need to produce a written judgment of the outcome. As I say, in terms of sanction, the court can impose imprisonment, fine, confiscation, or other punishment permitted under the law. And we'll look at the various punishments and sentencing guidelines in a moment. Next slide, please. So, you've got to the point of issuing the application. What is it that you have to prove? Now, as I've said earlier, we are focusing on a situation where proceedings have been brought, and the assertion is that they have not been brought bona fides. So the test in terms of Mackey is you must prove, firstly, that the impugned statement was false. You must prove that the respondent who verified it had no honest belief in its truth. And the final thing that you must prove is that they knew that the false statement was likely to interfere with the course of justice, although the point made in that quotation from Mackey is it's not generally going to be difficult that if you prove that somebody said something that was false without an honest belief in its truth in court proceedings, it's not likely to be too difficult to prove that they thought that it would affect the course of justice. Next slide, please. What about recklessness or negligence? So again, I won't read out all of the quotation from Al-Zahawi, but effectively what it says is this. Recklessness is enough or is sufficient mens rea to prove contempt. Negligence is not. And you'll note the final sentence of paragraph 8, optimism or even carelessness in the making of statements will not be sufficient to establish that a party is in contempt. So what the subjective element of the test is you must demonstrate that the person who made the statement consciously engaged and made a statement without an honest belief in its truth. Anything less than conscious engagement is likely to amount to mere carelessness and therefore not satisfy the test. And remember, the onus is upon the applicant to prove this to the criminal standard. Next slide, please. Can you rely on circumstantial evidence? Well, there's a lengthy quotation here from JSC, and I shan't read all of that out. I will simply make this point. As in any proceedings, you can rely upon circumstantial evidence to establish guilt, but if that circumstantial evidence points both ways, bearing in mind that the burden of proof to the criminal standard is on the applicant, it's unlikely that contempt will be satisfied. So if you are bringing an application relying upon circumstantial evidence, it's going to need to be particularly strong prior to it being a sensible step to take. Next slide, please. Also, give thought to who is the contemner. So in the context of this talk, we're suggesting claim brought by a claimant on the basis of false evidence. But what happens if the witness statement, which is said to contain false evidence, was prepared by a solicitor? Does that disclose contempt against the claimant? Well, the question is, in principle, it can. And the test is, does this arise from a deliberate act by the servant on behalf of the individual? So there may need to be an exploration as to how the false statement comes about to be made. And it is possible that an individual solicitor could be the subject of a contempt application if, for example, the claimant said, well, I said this and the solicitor recorded something different and knowingly did it. Now, that's unlikely to be something which is going to arise often, let's say, and in the context of this talk, probably is outside the scope of it. But recognise that anybody who interferes with the due administration of justice is in principle subject to the contempt jurisdiction. Next slide, please. So, at the permission stage, you don't need to prove that the contempt actually happened, but you need to prove a strong prima facie case. And so what the court will do is look at all the evidence in front of it and ask itself, does what I have in front of me raise a strong prima facie case of a criminal contempt? If that test is met, there are then the further conditions that have to be satisfied. Does it serve the public interest? Is it proportionate, bearing in mind the litigation, the sums in question and the like? Is it brought for a legitimate purpose? And we'll look at what legitimate purpose means in a moment. You don't genuinely, however, explore the applicant's motives for bringing the claim, as explained in Navigator number 1. So long as the legitimate purpose test is met, the fact that there might be a, if I could put it this way, retaliatory motive is unlikely to render it inappropriate for permission to be granted. You're also required to consider, or the court is required to consider, do the proceedings further the overriding objective? Although, as Patel and Patel makes clear, there's an obvious and clear public interest in holding to account those who deliberately tell lies in court. Next slide, please. Excuse me. So, DN talks about what is the legitimate purpose in bringing contempt proceedings. And you'll see that in the first couple of lines, it said that they are appropriate means of bringing to the court's attention serious rather than technical and still less involuntary breaches. Now, DN was in the context of an allegation of breaches of an order. But as DN goes on to say, if you are not bringing proceedings for a legitimate aim, the proceedings ought not to be allowed. And indications of illegitimate purposes are purely technical contempt, applications not directed at obtaining compliance with the order in question, and applications which on the face of the evidence have no real prospect of success. So if it's technical, if it's minor, and if it really feels like an attempt to strike back rather than draw to the court's attention serious breaches, there's a significant risk that you won't get permission at the permission stage. Next slide, please. What about timing? Well, the comments in Mackey were made in the context of a false statement of truth in a witness statement. And effectively, what Mackey says is, if somebody serves a witness statement which is said to be false, the appropriate time to determine whether that's right or not is at trial, where the court is applying the civil standard of proof rather than the criminal standard to isolated issues. So Mackey is a salutary warning, but in the context that we're discussing, unlikely to apply. But what it does say is, If, for example, somebody serves a witness statement with a statement of truth in the context of an application in the employment tribunal, it's unlikely that the court would entertain committal applications in that context. Next slide, please. So you've got through the permission stage, and at the final hearing, it's a trial like any other in the High Court, save that, of course, you've got a higher standard of procedural fairness and a criminal standard of proof. So you need to demonstrate the contempt on a criminal level, applying the test previously detailed, demonstrated in the usual way by evidence, cross-examination and submissions. Next slide, please. Now, in terms of sentence, what we see here is that effectively the court has a suite of powers that it can order. Imprisonment is very often the primary remedy, and the possibility is you can be sent to prison for up to 2 years, but only if the offence is so serious that only a custodial penalty can be justified. And you consider seriousness of offence, repletion and mitigation, and you must have regard to the Sentencing Council guidelines. Other options are suspended sentences, fines, and a particularly useful one is a split sanction, which might be immediate imprisonment to punish past breaches alongside a suspended sentence for future compliance. Next slide, please. Costs. Basically, committal proceedings, the usual rule applies. But if you bring contempt proceedings which are purely technical, you may be penalised in costs. If you withdraw a committal application, you're likely to pay the costs of that committal application. You can, in the ordinary context of litigation, offers are relevant to the discretion to exercise costs, and consider if indemnity costs are appropriate, bearing in mind the extent of the egregious breach. Next slide, please. So, case study. Some of you may be familiar with this decision. Claim brought by Mr. Adjou against Commerzbank. Wide-ranging allegations of discrimination made, including specific allegations of sexual harassment as regards a colleague. The Employment Tribunal dismissed the claims and ordered a payment of £20,000 worth of costs. So the bank brings a committal application alleging that the claimant's statement and his evidence on oath was false. 31 allegations of contempt were advanced, and Mrs. Justice Eadie gave permission that 12 of them be considered at a final hearing. In deciding whether permission should be granted, Mrs. Justice Eadie had regard to the findings of the Employment Tribunal in determining whether there was a strong prima facie case. At the full hearing, there was a preliminary application where Mr. Justice Martin Spencer concluded that he shouldn't have regard to the Employment Tribunal judgment when deciding whether the allegations were were made out at trial or not. But having heard all the evidence, he concluded that all 12 allegations were made out, and he committed the defendant to prison for 20 months. Next slide, please. The claimant appealed, and effectively you see the 4 grounds of appeal there. Shan't read them out. Next slide, please. What you will see is that effectively Mr. Adjou succeeded, and it was held that 20 months imprisonment was too much, that 12 months was the appropriate period of imprisonment. The court had initially given him 4 months off for mitigation, and the Court of Appeal therefore substituted a sentence of 8 months for 12 months. Note that the absence of remorse was considered to be an aggravating factor. So sorry. Finally, in the context of the sentencing control guideline and their application in this case, noting that there was no realistic prospect of rehabilitation, no remorse, and no indication that what he had done was wrong, it was felt that this was not an appropriate case to suspend the sentence. And you will see that regard was had to the effect of on the claimant's two children by the imposition of a custodial sentence, but the conclusion was that wasn't a reason to suspend the sentence. Next slide, please. Right, that's me done. I'll now hand over to Charlotte, who'll deal with her two parts of the talk. Thanks.
Thank you, Nick. So Nick has been talking about contempt as a way of dealing with dishonesty from litigants in person. I'm now going to move on to look at some other routes for dealing with other problems that can be caused by vexatious litigants. And the first of those is looking at injunctions to restrain communications. So if we move to the next slide, the problem, or put another way, when might this type of injunction be relevant for you to consider? Now, often, as you will well know, it's the lawyers who have the most contact from a litigant in person once proceedings are underway. So imagine a situation where you as the lawyers are receiving repeated abusive communications from a litigant in person. Hopefully not something that many of you have had to deal with on a regular basis, but unfortunately, as we know, it does happen. If it is happening, what can you do about it? Next slide, please. In the case of Titan and Okinola, Titan came up with a novel approach to this problem, which I'll come to in a moment. But just to set the scene first and understand the context, Mrs. Okinola was a former employee of Titan, a wealth management firm. She had brought 6 unsuccessful employment tribunal claims against Titan, and then she had pursued what she called herself a plan of vengeance by sending hundreds of abusive messages to Titan's lawyers, Quinn Emanuel, to their counsel and to others. And as a sign of how bad things were, Titan had started proceedings for breach of contract, breach of confidence and harassment, and they'd obtained an injunction to protect certain of Titan's employees from harassment by Mrs. Okinola. Unfortunately, she had breached that injunction, and as a result, she was given a 6-month suspended sentence, and she continued, though, sending abusive messages, notwithstanding that suspended sentence. Titan then applied for activation of the suspended sentence and for a further injunction to restrain her communications with its lawyers, Quinn Emanuel. And they said, although Quinn Emanuel might benefit from that order as well, it was being requested in order to ensure that Titan could properly pursue its proceedings against Mrs. Okinola for breach of confidence, breach of contract, etc., without interference. Now, if you're like me, you're probably thinking at this stage, well, just how bad were these communications? What are we talking about here? Well, unfortunately, the High Court judgment and the Court of Appeal judgment, which we'll come on to, don't set them out in detail. So you can't see exactly what the communications were, but we're told that they were repetitive and often pointless, sexually explicit and abusive, gratuitously distressing and demeaning, often including unparticularized and unsubstantiated allegations of professional misconduct and in some cases criminal conduct, and sometimes all in bold capitals, large text and with repeated exclamation marks, which was said to make them even more threatening. And there may be elements of those that you will recognize. We also get a flavour from another part of the High Court judgment of just what type of character Mrs. Okinola was and what sort of behaviour she was committing, because the High Court judgment refers to an incident at the end of one of the court days when the defendant apparently repeatedly shouted "scum" at junior counsel and the rest of the claimant's legal team, and then ended her outburst with the bold entreaty, "injunct that." So there's a level of confrontation there, obviously beyond the norm of just an irate litigant in person. If we move to the next slide, you'll see the order which was sought by Titan. So they decided to apply for an order restraining her communications as set out on the slide. It focused on her communications with or involving Titan's lawyers. So they wanted to stop her from publishing any message to or about the lawyers or persons acting for them, which abused, belittled, demeaned, or insulted them, and to prevent her from using profane or otherwise grossly offensive language, or imagery in communications addressed or copied to the lawyers. They had a carve-out for formally filed documents. Titan recognised that Mrs. Okinola couldn't be prevented from presenting her defence to their claims and from saying what she wanted in her defence. So this amounted to a really novel approach, because Titan weren't seeking an injunction here to regulate her interactions with them. You might recall they already had an injunction preventing her from harassing some of their employees, but they were seeking an injunction to regulate her interactions with a third party, their lawyers. Next slide, please. So this came before the High Court, and Mrs. Justice Hill, who heard the case, was very critical of Mrs. Okinola's conduct, and she found that it was impeding Titan's and Quinn Emanuel's ability to conduct the proceedings. She also found that it was impeding Quinn Emanuel's ability to fulfill their duties to Titan as Titan's legal representatives. But she was troubled by the fact that the injunction application had been brought by Titan, not to protect itself, she thought, but to protect its lawyers. And effectively, she said this was an injunction to prevent Quinn Emanuel from being harassed by Mrs. Okinola, and that Quinn Emanuel could have brought a claim for an injunction under the Protection from Harassment Act, as Titan had done for its own employees, but Quinn Emanuel hadn't done that. And her view was that in order to grant this relief, Quinn Emanuel themselves needed to have a cause of action to support the injunction, and Titan couldn't claim the relief on their behalf. And for those reasons, she found she didn't have jurisdiction and she refused the application. Now, if we move to the next slide, you'll see that Titan took the matter up to the Court of Appeal. Interestingly, the Court of Appeal judgment refers to part of the appeal being crowdfunded, which the Court of Appeal assumed was because Titan was seeing this case as something of a precedent in terms of how to deal with this sort of abusive communication from another party. But it's important to note that there had been some further developments since the High Court stage. So the suspended sentence, you might recall I said that Titan had applied to activate that because Mrs. Okinola had breached the protection from harassment order that they'd obtained. It had been activated, and Mrs. Okinola had, by the stage it came to the Court of Appeal, served a few months in prison. She was out now by the time of the Court of Appeal hearing, and she hadn't restarted the abusive communications since then. Titan also slightly changed what it was asking for in terms of the injunction which it sought. So it was then, but by the Court of Appeal stage, the order it was seeking was to prohibit her from addressing to legal representatives or any other person acting for, on behalf or at the instruction of them, any message or communication which was indecent or grossly offensive to or about any such representative or person. Again, there was a carve out for formally filed documents. And the language of this tweaked order that they were seeking mirrors the language of the Malicious Communications Act 1998, which makes a criminal offence out of certain abusive communications. It's also interesting to note that the appeal attracted the attention of the Attorney General, who sent along an advocate to the Court of Appeal. And the advocate for the Attorney General supported the idea that orders like this could be made in principle, but opposed it in this case because they said effectively it was unnecessary, given that she hadn't picked up the abusive communications since coming out of prison and the proceedings were coming to an end anyway. If we move to the next slide, we can look at what the Court of Appeal found. And in a nutshell, the Court of Appeal reached the same outcome as the High Court, but for slightly different reasons. And this is a very recent judgment from February this year. What the Court of Appeal found was that the High Court was wrong to say that it had no jurisdiction to make this order because of a lack of cause of action. The Court of Appeal said the court has an inherent common law power to protect the integrity of its process and its proceedings in the interests of justice. which would allow it to make an order of this nature. And they also said that conduct didn't have to go so far as to amount to criminal contempt of the nature that Nick was talking about, but that it would be easier to get an injunction like this if the conduct was across the threshold to be a criminal contempt. And the Court of Appeal said there's no one-size-fits-all test to apply to applications for this type of injunction, but it did set out some principles. Firstly, it said to get over the threshold to even be considering this type of injunction, there's got to be a threat of serious misconduct, which will, if unrestrained, create a material risk of interference with the integrity of the court's process or proceedings. So that's the sort of jurisdictional hurdle to engage the jurisdiction at all. If they went on to say then that if misconduct amounts to criminal contempt, you can move to the next stage of looking at the discretion to grant such an injunction. But if the conduct didn't get to that stage of being a criminal contempt, then the court has to consider arguments around freedom of expression under Article 10 of the ECHR and the Human Rights Act, and also consider the application of immunity in respect of statements made in the course of litigation. And they said that could be a pretty complicated process because it would require detailed consideration of the communications, which could be lengthy and often complicated by the fact that it's the nature of the sorts of communications you'd be looking at in these cases, that they might be mixed, where there's some abusive, gratuitous content mixed in with content which is properly directed at the proceedings. And so if you're not at the level of a criminal contempt, it will be more complicated. And then finally, they said the third stage will always be a question of discretion as to whether the court thinks it's just to make such an order and whether it's necessary. And if they do make an order, it must go no wider than necessary to do justice and to limit the interference with a defendant's right to freely conduct litigation as they see fit. So pulling together those threads and looking at how the Court of Appeal applied them in this case, they said High Court did have jurisdiction to make the order, but they were right to refuse it because for four reasons. First, it was too broad. It went beyond the end of proceedings. Second, it was unclear if the conduct amounted to a contempt in this case, and notably there, Titan hadn't asked the High Court or the Court of Appeal to decide that it did. Thirdly, Quinn Emanuel had an alternative and more convenient remedy open to it in respect of this behaviour under the Protection from Harassment Act, and that seems to have been a really important consideration for the Court of Appeal. And then finally, they said, well, the conduct stopped anyway because she stopped sending these abusive communications and the proceedings are nearing their conclusion, so an injunction isn't needed. So for all those reasons, they said not appropriate in this case. So stepping back for a moment, what lessons then can we take from this as to whether this is an effective tool against vexatious litigants who are sending abusive communications? Well, I think there's two things. Firstly, it shows that an injunction may be an option. It's a possibility, but obviously the threshold is very high. And it seems clear from this Court of Appeal judgment that it's never going to be a straightforward application, and there may well be better ways of dealing with the problem, either through contempt proceedings of the type discussed by Nick, or, as the court said Quinn Emanuel could have done in this case, by an application for an injunction under the Protection from Harassment Act. And realistically, it seems to me that opportunities for applying for these injunctions and where you're likely to get it are pretty limited in practice. So perhaps this case hasn't ended up being the precedent that Titan were intending when they brought the appeal. Next slide, please. So for the final section of this morning's talk, I'm going to look at civil restraint orders. What are civil restraint orders? If we move on to the next slide, please. Civil restraint orders are, in short, orders that prevent a litigant from taking certain steps in litigation without permission from a judge. And they are a very effective way of dealing with repeated litigation because effectively they insert a judge as a gatekeeper to decide whether claims or applications should be allowed to proceed or whether they are totally without merit, which is a concept we'll come on to. So I've set out in the table on the slide the 3 different types of civil restraint orders that can be made, and they effectively they ratchet up in terms of their impact on a litigant. So firstly, you have a limited civil restraint order. You can get these where you've got 2 or more applications which have been found to be totally without merit, and it will stop further applications being made in those proceedings without the permission of a judge. The next level up is an extended civil restraint order. So where there's been persistent issuing of claims or applications which are totally without merit, you can get an order that for up to 2 years, they can't bring a claim or application which concerns any matter involving, related to, or touching upon, or leading to those proceedings without permission from a judge. And then finally, the most far-reaching, a general CRO, which can be ordered where an extended CRO is possible but wouldn't be sufficient or appropriate, and these last for up to 3 years and restrain the making of any claim or application without permission of a judge. And the consequences of a CRO are that if an application or a claim is made without permission, it's automatically dismissed or struck out. Also note that in respect of extended CROs and general CROs, there's the possibility to extend them for a further term, so a further 2 years for extended and a further 3 years for general CROs, and potentially even further than that under the court's inherent jurisdiction. What does persistent mean in order to get an extended or a general CRO? Well, it means at least 3 claims or applications, potentially more. It's not a simple threshold, but is to be assessed in all the circumstances. We move to the next slide. You've heard me say that the criteria for getting a CRO of any kind is that applications or claims have been made which are totally without merit. And that's a concept which is central to the civil restraint order regime. What does totally without merit mean? Well, it's more than just bringing a claim or an application that was unsuccessful or even one that was weak. It means an application or claim that was bound to fail. In other words, it had no rational basis on which it could succeed. So that's a very high threshold, as you would expect, given the consequences of finding that something is totally without merit. Now, in the civil courts, CPR 3.46 and 23.12 provide that if a court strikes out a claim or application and they think it's totally without merit, then they have to record that at the time and go on to consider whether a CRO should be made. So 3.46 applies to claims and 23.12 with respect of applications. Now, in the tribunal, obviously there's no rule that an employment judge is required to record if a claim or application is totally without merit, but they can do so. And for reasons I'll come on to in a moment, they should be encouraged to do that where it's appropriate. Where you've got a totally without merit certification, that should be treated as conclusive. So if you then apply for a civil restraint order, the court who's considering that application doesn't have to go behind that certification. Having said that, if there are previous applications or claims which haven't been certified as totally without merit at the time, the court can still consider them, but it will have to decide for itself whether they were totally without merit. So it obviously makes for a more lengthy and uncertain process in terms of your application for a CRO. On to the next slide. And looking at process, how do you apply for a CRO? Well, CPR 311 gives the court power to make them, and Practice Direction 3C sets out procedure and also explains in more detail the scope of the different types of CROs and which judges can make which types of order and which courts they apply to. It's quite detailed, and I would recommend if you're looking at CROs, obviously you go and look at the practice direction very carefully. But in terms of making the application, you will need an application notice under Part 23 supported by evidence served on the other side, so it's made on notice. And the application and evidence should give the full procedural history and set out any previous totally without merit certifications that you've got. The recommendation is, in some of the case law, that there should be a bundle of all those previous proceedings and orders in date order. It might be, though, it's recognised in the authorities that might be excessive and very document heavy, and so it may be sufficient to summarise them in a witness statement and say the documents are available if needed by the court. That's an approach that we took in a recent case I was involved in. So we put a table into the witness statement setting out all the claims and said documents were available if necessary. Practice Direction 3C also includes as annexes forms of precedent CROs for each of the different types that you can use if you're applying, and also deals in detail with the consequences of for the subject of the CRO in terms of whether they can apply to amend or discharge, whether they can appeal, etc. We move to the next slide. Now, the jurisdiction under CPR 311 obviously governs the civil courts, Court of Appeal, High Court, County Court, etc., but not the Employment Tribunal. And there's nothing in the Employment Tribunal rules about CROs or giving them power to grant them. So there was a lack of clarity previously about whether or not you could get a CRO which covered Employment Tribunal proceedings, and also in respect of relying on claims that had been brought in the tribunal which were totally without merit. That's now been addressed by the cases on the slide. So firstly, in the Law Society in Otobo, the High Court there said that it did have an inherent jurisdiction to prevent interference with the proper course of justice and to assist inferior courts which didn't have the power to protect themselves, including the Employment Tribunal. So the High Court found that it did have the power to make a CRO relating to proceedings in the tribunal because the tribunal couldn't do that itself. And that was then followed in the case of Harold, and these are both cases which mine and Nick's colleague Adam Solomon did, where they agreed with that early decision in Otobo and again found that the High Court did have jurisdiction to make a CRO which extended to Employment Tribunal proceedings as well as any other civil proceedings. Now, in terms of practical tips from all of this, if you're faced with a vexatious litigant making repeated claims in the Employment Tribunal which get struck out, as I said earlier, it's a good idea to ask the employment judge at the time to certify them as totally without merit. Employment judges may well not do this unless you ask them to, because it's not generally on their radar. But for the reasons I've already explained, it makes your life much easier if later on you want to apply for a civil restraint order, because the High Court won't have to do its own process of deciding if those claims were totally without merit. They can just look at the fact that the tribunal judge at the time certified that they were. So that's a good idea to ask the judge at the time if you're in this situation. So in terms of CROs, it's clear from what I've said that they're not a quick fix. You need repeated totally without merit claims or applications in the first place. But if you are in a situation where you're faced with those, then they are a very effective way of bringing an end to repetitious and vexatious claims and inserting, as I said at the start, the judge, the court as a gatekeeper between the litigant and the issuing of such proceedings. And on to the final slide. I just want to mention vexatious litigant orders, which refer to civil proceedings orders or all proceedings orders. And these are orders which have the effect that a litigant can't bring proceedings without permission. Civil proceedings orders apply, as the name suggests, to civil claims, and all proceedings orders cover criminal proceedings as well. Now, these types of orders can only be applied for by the Attorney General, and bonus point to you if you recognise the picture of him on the slide. And when, if successful, they have the effect that I've just discussed, and they also mean that that litigant's name is published on a list, which you can look at online. Because they can only be applied for by the Attorney General, I'm not going to spend much time talking about them today, but if you want to if you want the Attorney General to make such an application, presumably be very much a last resort if all other avenues have failed to stop the behaviour, then you would need to submit a request to the government legal department setting out all your evidence for it. GLD then choose whether it warrants further investigation, and after investigation, if it warrants any such application. So, as I say, something rare, but may be there as an option if all other measures have failed.
This podcast was brought to you by Littleton Chambers. For more